anyone with knowledge about patents knows the importance of prior art. Prior art is evidence that shows that an idea should have never been granted a patent. Here is an example of a prior art. This prior art was published in 2004 in Sweden. It discloses swiping a finger on your phone to answer a phone call. In 2009, Apple was granted a patent on this exact function. It then sued Samsung for patent infringement. Samsung then spent millions and found this Swedish prior art. It was used to overturn Apple's billion-dollar judgment against it. In patent world, prior art is the smoking gun. But it's very difficult to find prior art because it's very difficult to differentiate potential but not relevant prior art against those that are. At Datanovo, we have found the solution. Using machine learning and artificial intelligence, we're able to capture the essence of how what human searchers do, improve it, and automate it to find the best prior available. It also removes the human perception error that has led to good prior being discarded because of the false perception of what the actual invention is. The best part, it's easy to use. Enter the patent number to get the results in seconds. But we offer more than just prior art. We also offer AI and analytics on every patent so that you can check your product for potential infringement or the strength of any patents, including your competitors, instantly. In 2005, in the US alone, 1,900 patents were challenged, 6,000 lawsuits were litigated, 130 patents purchased, and 600,000 applications filed. Each of these requires prior art searches. We charge $2,000 per search, which could potentially bring in hundreds of millions to $1 billion in annual revenue. The pricing comes from our subscription model. Our competitors charge between $15,000 to $20,000 per search. Instead, we charge one low price to capture the entire market. In all, we aim to be a one-stop shop for all things patents and generate revenue for every patent filed, granted, licensed, and litigated. We have a team of phenomenal experts in big data, AI, and machine learning. I've been practicing patent law for 13 years, having represented numerous Fortune 50 companies. Our team has inside connections within companies and law firms that have helped us open new doors every day. And today, the practice of litigating and creating patents is nothing new, but we have found an innovative way to generate revenue for every life cycle of a patent. Thank you.
Wow. That is amazing. Judges, you're going to have a field day. Go.
So look, it seems like a great service. One question I had when I was learning about this, you're familiar with the legal strategy that some firms don't want to know about prior art when they're coming up with something for fear that the penalties will be larger later if they ever have to go through litigation? Do you want to discuss that for a second?
Absolutely. That is called inequitable conduct. The reason behind that is because inventors have a hard time finding all things in the universe. And so when they judge your due diligence, lawyers would ask you, if you have conducted search, why haven't you found this particular prior art? And that's really the pitfall of not finding prior arts. And that has always been a problem. The Patent Office has experienced this for the past decades. It's because they don't have the tool, the technology, to find all things within the universe. We have. For the first time ever, we use machine learning to actually gather everything to help inventors find everything that is relevant to their invention. And the answer to the question is they're not finding anything. All they have to do is enter the patent number. They don't search anything. All they need is just one number, and it will automatically populate everything. And if they have a product, simply enter the description of the product, and that's it. There's no searching involved whatsoever. And this, in my word, will be sufficient to overcome that inequitable conduct that you're mentioning here.
So deciding if something is prior art versus invention seems like a lot of subjective reasoning and really understanding the technology that's represented, what the other content actually is. How does your system work to actually make those connections? And are you just serving up information to let me decide if it's better prior art? Or are you actually making a claim that this truly is prior art that I could actually stand on legally?
Absolutely, that too. But the power of machine learning and artificial intelligence is to be able to do everything behind the scene for you. And it gets even better over time as we feed the system with more prior art. And you should know you have 2 patents working on LinkedIn, and so you probably know the power of prior art presented before the patent office. And clearly, Paul, you are an advocate for AI, and so certainly you would appreciate the power of using intelligence for patent prior art searches.
Yeah, I'm actually an attorney as well, and one of the questions I sort of have with any product like this is, the challenge is that the law firms have a disincentive to see anything like this because of their billing model. And there's sort of incentive not really to be efficient. And can you talk about that a little bit?
Sure. Law firms do not conduct prior art searches, by the way. And I say because a lot of lawyers don't have the search background. And so they always farm it out to manual search firms. And manual search firms involve human and hands. The process generally takes, if I may show you, takes about 6 to 8 weeks to complete. For us, you get the same results in a matter of minutes. And it's really the difference. And instead of spending $15,000 to $20,000, we only charge $2,000 per search.
How do you think about the assurance of accuracy? You're talking about billion-dollar lawsuits, any risk of liability to your organization. Obviously, machine learning learns over time, and so it doesn't start out as 100% accurate. You may be at 89%, 92%. It may evolve over time. How do you think about that?
If I may show you this chart indicates the percentage of prior matching known court records. We actually check our results against all the prior that parties and defendants submitted to courts. And what we have found is 100% of the time, we have at least one common prior. 100% of the time, at least 5 common parts are the same. And 76% of the time, whatever that the defendant submitted are identical to the results that we have. So in terms of quality, we're unparalleled.
And we also have some additional prior arts that we found that they did not use. Now, maybe they already found it as well, but they chose not to use it, but we actually also found them as well.
And here's a chart in support of this assertion. We have about 45% of the patents, we have 1 to 9 uncited prior art, which are prior art that has never been cited by either the patent office or the inventor, probably because they have never knew existed. And of course, that number tapers off asymptotically. And then we have more than 40 plus uncited prior for almost 25% of all patents, which is remarkable.
One quick question, perhaps.
Last one.
Okay. How do you gather this data, globally?
We collect our data from a number of sources, very much like a bank that receives deposits from both public and private sources. We collect data from courts, from the patent office, for example, patents, articles, magazines, and also public domains and professional associations, including IEEE and Google. So we gather the data from a different variety of sources in order to create this prior database that we use.
Great. Hey guys, this is a great business.
Thank you.
Congratulations. Thanks, judges.